Welcome to the Jury Thinks What podcast. Part of the Lawyer Minds ecosystem, the Jury Thinks What podcast discusses everything there is to know about trying cases, from preparing the case before the lawsuit is filed, all the way to trial. And most importantly, how to understand what the jury is thinking. During our journey, we'll be talking to some of the brightest trial lawyers from many walks of life. What makes them successful? What makes them different? Do they have secrets to dealing with the jury? Let's find out. Here's your host of the Jury Thinks What podcast, Saul Gruber.
This is the Jury Thinks What, a podcast for trial lawyers on the Lawyer Minds ecosystem. As always, I am Saul Gruber from Gruber Trial Consulting as your host. Today, we have a very old friend of mine, Jeff Green from Peoria, Illinois. Jeff is one of those lawyers who is never afraid to pick a jury and does quite often, and his results are what we all strive to have. Whether it's a medical malpractice case, a construction case, a nursing home case, or a car wreck, Jeff's settlements and then $1 million plus verdicts are happening all the time. And Jeff is going to talk to us a little bit about his most recent verdict in a construction case and really dissect why he does certain things. And you're going to hear tips that you just didn't think of before, including how you can deal with pre-existing arthritic conditions on a shoulder tear. Jeff is a great lawyer and a member of the AAJ and the Illinois trial lawyers and a speaker all over the country. You're really going to enjoy this. Here he is, Jeff Green. And thank you. Again, like you just heard, we're here on the Jury Thinks What to listen to Jeff Green out of Peoria, Illinois. Jeff not only gets a lot of verdicts and really good verdicts, but what I love about Jeff, besides the fact that we're friends, is he gets them in different type of cases. A $1.7 million settlement in a semi-tractor case, an $11.2 million judgment in a drunk driving case, $5.4 million settlement in a medical malpractice case, 1.55 in a wrongful death case. So they run the gamut. And the one thing that's always really consistent for Jeff is the work he puts in the case and the result. And that's really why we asked him to be here. Hi, Jeff. How you doing?
Good, Sal. How you been?
Pretty good. Thanks for coming on. I know we talked a little while, a few months ago about getting you on, and you were tied up and I was tied up, but I'm thrilled that you're on now. One of the reasons why I wanted to bring you on was the verdict you got during the pandemic. Which, if memory serves, was a construction type case. And I'm looking at the verdict sheet against First Assembly of God. And I guess that was in Peoria?
Yeah, it was in Peoria County.
Yeah, I always worry personally whenever I'm suing God. And I guess really not suing God, but it was a church.
Yeah, it was the case involved a remodel of a widow's home with 4 kids. The husband had recently passed away. So we had originally sued a carpenter in the church and a construction company. There was 2 parts of the project. There was a remodel that the church was organizing and working on. And there was an addition to the house being added onto the back of the home. What really happened was the carpenter who built these stairs settled out of the case. And after some other motion practice, we were left with one defendant, and that was the church. And the church said,
let me slow you down, because I know when I practiced, we were always facing that issue where we maybe bring a case against the doctor, a rehab facility, and the nursing home. The 2 most liable parties settle out. Now we're there with one of the parties. How do you figure out whether you want to go forward in trial in that, or you want to just, tell your client to just walk away?
I tend not to, I think you get into a case where you have a medical case or you've got multiple parties, sometimes in those cases, and everyone's getting sued, so there's no empty chair defense. I think I had the very surprising opinion, at least surprising amongst the defense lawyers in the case, that the church was actually the target defendant.
That's even better.
They did a lot of the organizing. They had, I think, conducted themselves during the case, during discovery, in a very poor way.
Wait a minute.
They would tell- they would-
You're saying a defendant wasn't, or at least the defense attorney wasn't necessarily honest and forthcoming in discovery?
No, and they, this was, I've done a lot of trials. This was probably, ironically, the most contentious trial. This is by far the most contentious trial I've been involved in. It was like that the whole time. We didn't get discovery. And we're not talking about audit trails of medical records. We're talking about text message and emails between contractors. We're talking about receipts and checks written by what they claim was a 501c3 charitable organization. We're talking about basic documents. The church also, and we've had filed a spoliation case for them because what happened was there was a stair collapse. And there was some broken horse or support of the stair. So it's a very small piece of wood. About what the testimony was, it's small enough you could fit it in a glove box. And that wood and the broken stair was removed off the scene. And within 90 minutes of when an investigator comes out, that wood is gone. And
oh my God.
And then in discovery, the evidence is that it was the head of the church construction group that went out there immediately and took that wood off the scene.
So they removed, I just want to make sure I got this straight, at least the allegation. Well, no, the testimony is the main defendant removed the faulty piece right after the accident took place.
Now, they hedged that. They said, well, I think I took it. Maybe the carpenter took it. The carpenter said, I didn't take it. We were both there, so he must have taken it. And then it was, well, what happened to it? And it was, well, we either threw it away in the dumpster on the construction site. They had a dumpster there at the time. Or because, this is a charity project, we're trying to save money, I would take a lot of the, discarded wood or the scrap materials home and I would burn it in a burn fire or a burn pit. And so
some would say they destroyed the evidence.
Yeah. So, and it was like, well, of course at trial, I don't know what happened to it. I'm not sure what happened to it, but we had the testimony. So you have an angel defendant of someone who says, we're doing a good deed. We're helping the community. We're doing this for, all these great reasons, but you have conduct involved in the removal of the wood and ongoing through discovery, which shows that they are much less than forthright.
Let me take you back a little bit, because I find this fascinating because I know there's so many lawyers who have these type of issues, whatever type of case it is, and a lot of us don't necessarily have the foresight and maybe the energy that you have in proving certain things. So let's just take a step back. So we can agree you're a trial lawyer, right?
Yes.
And unlike some other people I talk to, trial lawyers actually try cases. What got you interested in actually being a trial lawyer to begin with?
I grew up, the son of a union laborer. The block I grew up on was mostly Caterpillar union workers. It was a very blue collar neighborhood. And it just seemed like whenever someone had a legal matter or something against either Caterpillar, a big corporation, or an insurance company, the folks where we lived came out with the short end of the stick. And so it's almost a part of who I was growing up. It's a part of where I grew up at. And, the things being done to folks by insurance companies and big corporations, and you're as aware of them as anyone, or it's just abhorrent.
Yeah.
And you got to balance the scales somehow. And it's, if you're going to be a lawyer, do something you enjoy. You hear all these horror stories about lawyers who hate their jobs. Hey, there's something for everyone in this profession. And you find what you like and find what you feel passionate about, and you pursue it.
When I practiced, one of the things I always felt, and I don't know if it's because I was a little crazy or a lot crazy, depending on who you talk to, but I felt that these corporations, not all corporations, but the ones we kept going up against, just thought they could be a bully. and they would throw money to their lawyers and to different things and just say your client doesn't matter and their issues don't matter, which just would infuriate me. How do you deal with that?
You go to trial. The people that take that position, I mean, they either pay at the last second or they don't want to pay at all. In this case, we just tried the last few cases we've tried have been cases where they don't want to pay at all. You're talking about cases where the offers are a fraction of what the medical bills are. They're a fraction of what the lost wages are. And so, I have been told that I can be ill-tempered or short-tempered at times, and you just kind of channel that and get ready for trial. And, you work and work and work and work and get ready, and you hope for the best outcome for your client.
It's funny. It took me years and years and years to figure out that I never needed to get upset when the insurance company or the nursing home would say to me, well, we only value the case at X, or we don't think you have a case. And I would, when I was younger, I would jump up and down. I would say, well, I would write them 5-page letters. This is why you're wrong. And then it dawned on me after a couple trials in a row, which went very well for the plaintiff. You know what? Thank you. We'll just pick a jury. We don't need to argue about anything. We have a disagreement on the value of the case. Let's take it to trial. And I noticed when my response changed, the response changed. All of a sudden it's, well, wait a minute, maybe one can mediate it, or wait a minute, maybe how much more money do you really want? You find that happens to you now that you're trying an awful lot of cases?
I would say yes. Especially with some kind of recent trucking cases. I've had the defense reach out to me and say, look, do you want to discuss an early resolution? And, that doesn't happen that often. And we've been able to resolve some cases, I think, very early on in litigation, especially like in the central Illinois part of the state, kind of where I practice, or where we practice mostly, because I think we've established that reputation, like we'll take any case to trial.
Right.
And I think that obviously that helps us. It helps our clients, especially. And there's a lot of cases I'm like, look, this case is not going to get resolved early. We're going to have to get past summary judgment. We're going to have to get past a certain point. But you don't have the credibility with the insurance company or the defendant until you've gone in there and done it a few times.
Right.
I mean, I found early on, back when I started doing this, and you're doing some soft tissue cases, and maybe you're getting some bad outcomes, and I've gotten zeros before. Even seeing that, defense lawyers are like, well, maybe we should pay because we're going to have to pay for a trial on a small case. So, I mean, you learn by doing. When you're not out on your own and you're being handed cases by your firm or by a managing partner, you don't get to choose every battle sometimes when you're a younger lawyer. But there's something to be learned, I think, in all of those.
Yeah, I can remember when I was sworn in the bar in '88 in New Jersey. Yes, I'm that old. And the managing partner of the firm that hired me gave me what he called the 10 worst cases in the office. There were horrible cases. And he said, we don't walk away from a fight. These are our clients. And if we can't settle it, they deserve their right to testify in court. Here they are. Don't take a little settlement unless the client orders you to. Go try them. And that's what I did. And I learned early on what you just said. You know what? If you're going to go do it, that's when you really figure out how to try the case and which way to go, making those decisions. And once you start doing that, everything changes from the other side.
Yeah. At the beginning, you're doing like what the defense likes to call a soft tissue case, which I'll call a connective tissue injury. Okay. Right. And you do a few of those, and it's like I had done a few. We're getting middling outcomes. Tried another one, and we get this great outcome. Same type of accident, same type of impact, same type of injury. The only difference was that accident happened on Halloween night when kids are out trick or treating.
Interesting.
And the jury was angry that someone would drive carelessly. It wasn't a terrible, it wasn't like a gross negligence type situation. Someone ran or rolled through a stop sign. And that was the difference, was that it was Halloween night and the kids were out trick-or-treating.
So people could envision that was their kids trick or treating, and all of a sudden it's a threat to the community, and now they're upset.
Immediately, yeah, and that was the difference in the case. It was almost a carbon copy of the other cases, except for the fact that without knowing it, the tentacles of danger were kind of spread with, okay, you've got to exercise more caution under those circumstances. And as someone who hadn't really studied, he hadn't read Reptile or hadn't read Rick Friedman or hadn't listened to Mark Lanier at the time, it's like, oh, okay, there's something to this about why is this dangerous? Why is this a bad thing to everyone? And to the 12 people in the jury, not just the person sitting at the table with you.
So interesting. So now, I mean, you were lucky enough to learn that early on. Do you find that you're looking at all your cases in that way? How you can frame them so that they have that same cachet when bringing it to a jury?
Absolutely. I know in the case we just tried this case, our client was a union electrician. He was coming up and down stairs. The stairs had been there for a while. And the evidence was our client had actually gone up and down the stairs about 20 times the day before and the day he was hurt. But we had evidence that there had been HVAC guys and plumbers going in and out of there. There'd been other people going up and down the stairs. There'd been church volunteers going up the stairs. And so the way we presented the case was, this wasn't an issue of our client, Darren Adams, being hurt. This is an issue where we have these stairs. They're made out of compromised, cracked, and fissured wood. You have people going up and down them for a couple weeks before they finally collapse. Those are other workers, they're plumbers, they're HVAC workers, they're other people with families. They're church volunteers. And this isn't an issue of when something was going to happen. It wasn't an issue of if something was going to happen or somebody was going to get hurt. It was an issue of just when.
So really, your client just was the unlucky one. Nothing he did or didn't do that affected it. It could have been the HVAC person, two people before him. It could have been the carpenter after him. It was the fact that the stairs were just a ticking time bomb waiting to hurt somebody.
Absolutely.
It's funny. I speak, as you know, in a lot of state TLAs and have clients all over the country. And one thing when I work with a younger lawyer and we start talking about, well, what's this case really about? Especially in the nursing home world, where they start telling me about wounds and fractures, I kind of say, well, is that what the case is about? Or is the case really about a defendant who decides they'd rather pocket money than put it back into training, staffing, and having people there? And this could have happened to anyone that was in the facility. And sometimes, believe it or not, I get looks from other lawyers saying, well, I don't see why that matters.
Yeah, and that's, in this case, so our only defendant left at trial is a church. I would say that they were very much cloaking themselves in religion in their alleged good deeds. And so the very first thing when we talked to the jury in opening was, this is an important case because all Americans deserve a safe place to work. It's a really broad,
interesting
theme, but we wanted to choose a theme that overarched faith and religion.
So you're looking at a defendant that cloaks themselves in religion. I guess, what are they? They're rebuilding someone's home as a charitable endeavor, or is it a money-making endeavor?
Well, it depends if you ask me or the defense attorney whether it was a money-making endeavor.
well, let's go through both answers.
Yeah, they said it was charitable. They're a 501c3 tax-exempt wing of the church. Now, the interesting thing is, at the beginning of this case, their name was Compelled Construction, and they are a wing of the church who does construction projects, residential construction projects to help people out. Now, the weird thing was, in this case, the deposition that was going on of the church representative, literally when the lockdown happened, when the president came out and said the lockdown is starting, we were sitting in that deposition stopped.
Wow.
When we reconvened that deposition and 6 months later in October, I started asking him questions. And he says, oh, by the way, I just want you to know the name of the group is different now. I'm like, well, what's the name now? And he says, well, now it's Compelled Construction Ministry. Why did you change it? Well, I wanted to make sure no one gets the wrong idea. Like I think maybe you did, that this is some type of business and it's a 501c3.
So they changed their name because you sued them?
That was part of his kind of long-winded response, but that was enough for me.
Right.
And I, and also ironically, between that time, the church changed their name from the beginning of the case to the end of the case. And so I told the jurors, I said in opening, I said, a ministry in name only. Quite literally, they changed their name, and I didn't go further into than that, but they changed their name from the beginning of this case to today when we're in court. Is it a proper argument to make that, well, maybe they changed their name because of this case or anything else? Right. I didn't have to say that. The implication, it's just a simple fact. And
sure,
you draw the conclusions.
So you're you're looking at this case from a trial point of view, and you've identified two things for us, which I think are pretty interesting. One is, one of the main defenses is that they're going to cloak themselves in this religion and charitable, more probably is a better way of saying it than religious, but a religious charitable endeavor. And how are you going to deal with that? Right? You got to conquer that defense somehow. But two, you also need some sort of theme, overarching theme that can compete in some way with the religious defense. Is that kind of what we're talking about?
Absolutely. Absolutely. And we knew that with this defendant, with this kind of case, we had to start fast. And when I say start fast, we had to take some of the shine off of the appeal of the church as defendant. Sure. We had to get a couple things out in evidence or put a couple things in front of the jury that at least made some of them look at the church with a little bit of what I'll call side eye of, okay, well, you're saying this, but what about this? You're saying that this was all you wanted to do was do a good thing. Why did the evidence disappear from the scene? Right. You're saying you're not for profit. And one of the things is this was their first project, they said. It's our first project, out of the box. And we made them, after, much fighting, give us their checks from that period of time. This is the only project they had going on. They testified. There's like 20 missing checks in the check numbers. Now, I don't bring this up in discovery. I save it for trial in case we end up here. I'm like, where are your missing checks? Right. I don't know. Okay.
So, but aren't you worried? I mean, this is the kind of thing that we talk about all the time is, if the evidence, at least that you're putting forth at trial, doesn't remove the shine from the religious charitable aspect, you lose the case, because now you're enhancing them and you're losing all credibility. How did you figure out how you wanted to do that with that risk being there?
We knew we had to take some risks because of the defendant. And so it was, we took some calculated risk. You always do in a trial, I think, particularly in this case. One of the things we brought back was they're like, well, look at all this we're doing. Look at all this money we're putting into this project and that kind of thing. Well, at the end of the first day of evidence, the last question, that we got out in front of the jury was, how much would the lumber have cost to buy new supports? Because what the evidence was that they had removed the stairs to put siding on at that part of the project. So they ripped off the old stairs, put the siding up, and then built the temporary stairs for the construction part of the project with that old wood. And so the question of the carpenter, and the church didn't build the stairs, the carpenter built the stairs. And so the question was, how much would have cost to buy new supports or new horses to support the stairs? And the last thing he said in front of the jury, the first day of evidence, was it would have cost $60. And so then it becomes, okay, $60 is enough to make this not happen. Now you can get on your high horse when you present your case and talk about all the time and all the money you put into this case. And we can just keep bringing it back around to, but $60 would have been enough to prevent this from happening.
Well, that's unbelievable. And that was the last thing the jury heard on that first day of testimony?
First day of testimony that's the last thing. And I stopped and looked at the guys like, your witness. And it was probably about 4:45. And I'm shocked he didn't start. And he's like, Judge, I'm going to be a while. I'll start tomorrow. And I thought, perfect. That's the last thing they heard today. Like, we're good first day.
So that's an incredible. I wasn't aware of that. And you and I talked about this case a little bit a couple months ago too. So it's unbelievable when you're able to stop testimony with that type of information for the plaintiff out there for them to think about and consider. That's like a goal we always have, and it never happens. But good job.
We had some things break right, just like kind of on timing. The head of the church construction group was the end of the next day. He was a licensed architect. He was kind of the organizer and the person that thought of this part of the church. He was a member of the church, obviously. And so part of their defense was, well, this gentleman who is the architect and the organizer of the church construction branch, in his day job, he only does commercial projects. He doesn't do residential projects.
Right.
He doesn't know what the residential building code is. He's just doing this because he wants to do good things. And so in opening, they built that up, and they said, this man builds schools and hospitals for the community. And so the last thing we asked him at the end of that day of testimony was, were these stairs sufficient? Were these stairs safe? And he says, well, I don't know. I don't know residential construction. And so we ended with, are they safe enough for a school? No. Are they safe enough for a hospital? No. Your witness. Again, it's like 4:30. Well, Judge, I'm going to be a while, so I think I'll just start tomorrow.
So 2 days in a row, it would have cost $60 to make them safe. The second day, the person in charge said he doesn't know, they would not have been good enough for a school or a hospital. That's karma, brother. That's pretty impressive.
Sometimes the timing, obviously, it just works out fortuitously. But you always kind of save. I always kind of try to save. Like, all right, look, I'm going to start with something good. I'm going to end with something good. And this isn't a cross. This is our part of the case. One of the witnesses was adverse, and if you can end with something good like that at the end of the day, it pays off. Organize your exam. Make sure you've got that ace up your sleeve for the end, and stop there. And then I think you've got a better chance of ending on something like that.
That's phenomenal advice for everybody when you're doing your cross, even if you have to write it out and then re-sequence it to make sure that you have something to catch their attention in the beginning and something to leave them saying, oh, geez, at the end. I love that. Thanks. Thanks, Jeff. That's incredible. That's an incredible tip. Now, I'm curious, because I know everybody does it a little bit differently. Now, were you aware that would have only cost $60 to get new wood? Did you find that out in discovery, or did you just take a chance and ask that question?
We took a chance. We knew it wasn't going to be an exorbitant amount.
Right.
Now, the one thing that I really made careful to couch the questions, though, before we got there, was we're trying this case in June. And this is literally the period of time where you're seeing things on the news about the soaring prices of lumber.
Right.
And so I said, hey, look, I know lumber costs a lot now. I get it. When this happened back in 2017, how much do these support horses cost for this project? I didn't think that number was going to be as low as that. We didn't get it in discovery, but we'd gone through some of the invoices and tried to parse out which part would have, because they eventually did build new stairs, because these are temporary stairs. And so we tried to figure out, okay, what's the lumber going to cost here? We figured it'd be a few $100, which is still not very much in context.
Right.
So when he gave us this, he said $60 to $70. We thought, okay, that'll work. That'll do.
So you actually did your investigation and your homework to know about what it would cost, but you left the big question for trial. That's pretty ballsy.
Well, if you don't, I don't know, with a defendant like this, if you don't wait on some of this stuff and you put some of this stuff out there, a good defense lawyer is just going to come up with some type of BS response to it before you get it out.
Sure. I agree with you. I mean, and probably you're the same way. When we were in law school, we were always taught on cross-examination, you don't ask a question you don't know the answer to. And everybody was very rigid in having their debt transcript with them while they were doing cross-examination. And it took a few years, probably more than 10 or 15, for me to realize that's not really it. It's you don't ask a question that you don't know the answer to, or that you don't care what the answer is. And in your case, you kind of knew where they were going, whether you knew it was $60 or not. You did the work to know it would be in some sort of parameter, so you didn't care where in that parameter it would be.
Right. And that's kind of the old adage and the old Irving Younger
Sure.
10 commandments of cross-examination. I have never had a trial where I haven't asked questions, multiple questions. I don't know what the answer is going to be on cross. Now I have an idea of what the range of the answer is going to be.
Sure.
And, I talked about this during a cross-examine presentation. I said, you have to take risks on cross in some of these cases.
Sure you do.
Now, they need to be calculated risks and not degenerative gambler. It's 3 a.m. and I'm at the casino risks, but you've got to take some risks from time to time with some of this stuff.
I don't think you get big verdicts unless you step out of the box a little, be creative, set them up so that final payoff question, quite frankly, doesn't matter what their answer is, because you've got them from the 5 questions before then. And that sounds like what you did with the $60, because whether it was $60 or $350, it doesn't change your argument.
Absolutely. I mean, it's going to be within the range of something you're going to be able to use in the context of how they're defending the case.
So with these 2 large issues that you have there, I need an overarching theme of safety, and I need to diminish the shine on this particular defendant. How do you deal with that in voir dire of this trial?
I mean, we kind of went right at it. The first thing we talked to them, you kind of go through your general civil voir dire about burden of proof and all those things. We used 5 scaled questions during our voir dire.
And tell me what you mean by a scaled question.
I'll give you an example. The importance of a safe workplace. Do you believe it is important that people have a safe place to work? Show me where you're at, 1 to 5. 1 very important, 5 not important. And that way, you want questions where jurors have a chance. You want to do a hybrid, I think.
Yeah.
You want to get opinions, prejudices, how they feel about personal injury lawsuits. Let them talk about some of that stuff. But some of these things, if you either have a limited time to choose a jury, you want something that you can calculate along with your gut feeling. And it's like if you do a few scaled questions, you can come up with, okay, this person's a 25 or this person's a 5.
Right.
Is which end of what you want. If you've got to make a quick, decision on whether to keep someone or get rid of them. So we did scaled questions on safe workplaces, and we did a scaled question on whether or not people would be comfortable awarding a verdict against a religious institution or entity. Mm-hmm. And so we kind of stuck that in with workplace safety and whether they were comfortable awarding hundreds of thousands of dollars or $1 million for a work injury.
So you were able to hit the safety issue, the religious issue, and the bane of all of our existence, are you willing to give a large verdict issue? Correct.
In our main damage, we kind of linked that question to one of our big losses was, so this gentleman could work. He ended up being an armored truck driver. But in that job, he made okay money, but he didn't have his benefits. And so the question was, how do you feel about awarding a verdict? Are you comfortable awarding a verdict for hundreds of thousands of dollars just on the element of loss of benefits and insurance? And so we just really aimed it kind of at that one, I think, key element of damages.
That's fascinating. Did you also talk to them at all? How long do you have for voir dire in Peoria?
We don't have a limit.
Okay.
So I think it took us about a day plus 2 hours to pick the jury. So we don't have a ton.
Oh, that's great. Usually. And were you able to talk to them a little bit about how important benefits were to each and every one of those people and what they thought of benefits?
Yes. Yeah. It came through very quickly who was a member of families of people that had union jobs where they had the types of benefits available that our client did. When you're looking at great benefits, great pension,
right?
An hourly contribution, no matching, those kinds of things. So we were able to flush all of that out and kind of get into those issues with each of them.
And I ask this of everybody when we talk about specific trials. Did you reach any conclusion before you went in there of what your ideal juror would be?
This kind of comes back to like my general approach to jurors and ideal jurors, I think, and especially where we practice in kind of in Peoria in the middle of Illinois, it's pretty conservative. You know, we've
Right.
had a Republican congressman my entire life with no hopes of going blue, really. And so I don't think in terms of my ideal juror. I think in terms of what I can't have is a juror. And so in this case, I think the first thing was people, because of their faith, that would simply not allow themselves to award a large verdict against the church or a nonprofit entity. And so instead of kind of saying, what's our ideal juror? I think we looked at it as we have to get rid of people that I over-identify as religious, and they're like, we just can't take that out of our decision making.
Right.
I think at the end of the case, I think our ideal juror was, we had a few jurors, I think, that had children that worked in the trades, adult children, obviously, that worked in the trades and on construction sites. And I think those jurors ended up really identifying as the importance of a safe construction site, the importance of a safe workplace for anyone and everyone on the site, not just the religious volunteers, the church volunteers, but for the electricians and the masonry and everyone there on the site. So.
Yeah, I love what you said, and is you're really deselecting the jury. You're getting rid of the people that are going to torpedo your case, as opposed to, quote unquote, stacking it with people who are going to like your case.
Stacking the jury where I practice is not a realistic possibility. It's like, get rid of your Unabomber jurors.
Right.
Get rid of the jurors that are going to go back there and that aren't going to be reasonable, that are already cut off before the case starts. You've got to get rid of those people, from the beginning.
It's funny. I have this debate with defense consultants all the time, that whenever there's a large verdict, automatically it becomes a nuclear verdict. And obviously the jury was stacked with people who weren't going to follow the evidence and were just going to give a lot of money. And I always say to them, I've tried so many cases. I've never been able, at least maybe it's just me, I don't know how to stack a jury, right? Because there's just not enough people that are willing to give money away willy-nilly. I don't care where you are. I don't care what jurisdiction you're in. I mean, it's just not, it doesn't happen. But what we do is get rid of the jurors who, as you say, are the Unabomber jurors, meaning the ones that are going to torpedo anything that we do and not agree with anything we say. I love that. What type of, I know you talked about the question, the scaled questions. Do you ever use the which way do you lean questions instead of the scaled questions?
You mean politically?
No, just when you're taking the when you're asking them questions. I'll give you an example. Some people, I've done this in a couple different ways in wrongful death cases, where I say some people say that we're all going to die, especially as we get older, and it doesn't really matter how you die because it's coming. Others say it absolutely matters how you die. Which way do you lean in that thought process, and get them to start talking that way?
Yeah. I mean, that's a kind of a common thing, and it's case dependent. In a wrongful death case, we would absolutely ask those kinds of questions. And one of the things I would, in Illinois, we get, if it's a wrongful death case, we get damages for grief and sorrow. And so you'd kind of start off with a question along the lines of what you've said, and we would kind of lead into or link that into, how do you feel about awarding money damages for grief and sorrow if you feel everyone's going to lose their parents if things play out
Right.
naturally, or everyone's going to lose this? How do you feel about grief and sorrow damages in this type of circumstance? And you'll very quickly, that question can really get tort reformers not like, well, I'll give money for wages, but grief and sorrow, that sounds crazy to me. Like, you're going to ask me for money for grief and sorrow? Well, that's the law. How do you feel about that? Or you'll get obviously jurors who are like, yeah, if a little boy's dad gets killed, I'm going to award money for grief and sorrow. That's terrible.
So now getting back to this trial, we've got the jury. You think you're okay with it. You've got your overarching theme, and you've got the one really big issue on the other side, which is they're a religious charitable 501c3 company just trying to do something for people who need help, which sounds pretty bad. So how do you start putting together what you think would be really good evidence that they're not as wholesome as they claim to be?
Well, we led with the fact that, like, look, they immediately ran out to the work site and took things off the site. And the way we kind of dealt with that, and they obviously had this response of, well, we didn't do it to obscure anything. We did it because we did this, every week we go out and take some wood off the site and burn it, and he testified, well, there was another period of time where we tore off a whole bunch of wood. I took it home and I burned it. And so one of the ways we dealt with that was to say, I just totally lost my train of thought.
I'll edit it. I'll take that out. Let me go back and ask it again. It's the beauty of it not being live, by the way, Jeff.
Yeah.
Yesterday, I had to do it with Christian, but we had to get 4 minutes because we realized we were both just talking about nothing. So let's get back. So what, you're left with this issue of, wow, they seem to be the defendant of God. How do you make the determination, and how do you present evidence to show that they're not as wholesome as they claim to be?
Because they took a different position outside the courtroom than they did inside the courtroom. Now, they didn't produce any of this stuff, but the church ran a Facebook group for this construction entity or this part of their church. And so we screenshotted all of that well before the trial. We had it all in the bag in case those things would disappear or anything else. But once we had put all that together from social media and the post of this part of the church, we sent another discovery request because we want to make sure we didn't get barred from using them in impeachment or putting them in evidence. He said, I want any and all evidence of any potential destruction of any construction materials from the site. Okay. We did that because we had a picture of a bonfire that the guy put up at his house burning construction materials. And we ended up getting that into evidence because we said, Judge, they're saying he's not sure if he burned during this week. Here's a picture of him burning during this week. And the caption was, the old stairs burning real good. and so, on the third day of trial, when we've been talking about this, we've talked about it in opening, and they're refuting it, acting like we're just coming out of left field with this stuff. And I think the other attorney was so shocked when I held it up and I gave it to him. I said, is this something you posted on Facebook? Because it wasn't disclosed. And it's a bonfire at his house burning construction materials. And I said, is that the first time you burned after the plaintiff was hurt? Well, I guess it was. Put this into evidence. Okay.
Wow.
The change between, and this thing was constantly like, look at this house we're building for this widow. Look at these little kids on the construction site. Look at our progress. Look at all the good we're doing. And every picture has this logo with the cross and compelled construction and the church logo on it. And so one of our themes was this. Outside of this courtroom, they want recognition for doing these good deeds. Outside of this courtroom, they want recognition in the community. They want credit. They want the glory for doing this project. Now we're here in this courtroom and they're refusing responsibility. Suddenly, it's not our project. It's not our problem. It's not our fault. You can see in these pictures when they're stamping their logo on it in 2017 and 2018 and taking pictures with the family and putting it out there into the web and Facebook and everything else. They want credit. It is very clearly their project. In front of you this week, in the last week and a half, not our project, not our problem.
So now one of your themes is responsibility.
Yeah.
Which
absolutely.
should, we think, I'm curious what you think about this, which should resonate with A, the conservative crowd, and B, quite frankly, the religious crowd.
Yeah. I think it did. We didn't get, obviously we still had many religious people and many consistent churchgoers on the jury. We knew at the beginning, and we'd focus group this case, that we were going to have religious people and people of faith on the jury, and they were going to be incumbent upon us getting a good verdict. That at the end of the case, we had to have them look at what happened in the conduct of this church, in the conduct of this construction entity of the church, and look at what they did and how they did things, and have them say, this isn't how my church would do it. And we thought we would have to get them to agree with that idea to get them to side with the plaintiff.
Wow.
And so a lot of this was, okay, we got into some of these things. We put the pastor up. Now, we didn't depose the pastor, but they have internet sites, they have a website. And so on their website, you can see all the different ministries. They've got 7 or 8 different ministries. And I didn't know the answer to this question when I asked him, but I said to him, there was a separate checking account for this construction, what I'll call wing of this church. The checking account, the address on the checking account was not the church's address. The address on the checking account was Mr. Architect, church organizer's home address. And so I said to him, I said, how many other ministries have separate checking accounts from the church? 0. How many other ministries have separate checking accounts where the church member's address is where the checks go or they're labeled at? None. Okay. So they seem kind of, if you put that all by itself, maybe it seems innocuous.
Right.
When you put it with, okay, this is the same guy that took the evidence off the scene. You've got 20 missing checks from the same period of time. You don't know where they went. You're giving your 501c3 tax ID number out to the subcontractors on the case also to buy supplies. You get it, did you give us this text message? And did we have to go out and get this from another defendant? Do we have to go out and get this from another party, from the carpenter? Did you give this to us? You asked for it. Here this is. Did you give it to us? No. Once you kind of start, we kind of had to build it gradually, and you kind of save. I think I kind of saved the things that were a little edgier, I think, for later. Once we kind of started, you took evidence off the scene, didn't you?
Right.
Whether you did it for ill intent or not, you removed it right away. And you kind of kept going with that. At one point, I know the third day at trial, I got an objection and we had a sidebar. And the defense attorney was like, Judge, he's acting like they have committed financial fraud. And I said, well, Judge, I haven't said that. I'm just asking questions. And the judge said, okay. And he kind of shut it down. He said, you're kind of trying this like it's a financial fraud case today. Well, yeah, okay. You're
You got to
missing
take your shots.
You're missing checks. You're missing receipts you're required to keep under the law if you're 501c3, and you're not documenting anything.
Did they have any reasons why they're missing checks, not documenting anything, not keeping receipts?
The kind of general response from that church member was, well, I didn't think we'd be here. My wife's my bookkeeper, that kind of thing, which is, we didn't really know if we were going to call the pastor. And once we kind of got some of this stuff out, then we put him up and said, look, you're a 501c3. Here's your signature on your application. Here's your signature on all the certifications and your tax exempt documentation. Do you understand what that means? You don't have to pay taxes. You can buy goods without being taxed. You're not like me when I go out to Menards or Lowe's. You're not like a normal construction company. You know what those requirements are. Did you monitor this account? Did you monitor what's going on with this account? And I think this guy was like, he watched the rest of the trial. And this is towards the end. This is like kind of, I think, towards the end of the first week or second week. And he's like, I'm going to be like, I don't know what this guy was doing. And so, once you kind of get there, and he's backing away from the conduct of the guy running that wing of the church. Well, now you've got, I think, the church-going members of the jury looking at this saying, what's going on here? We had some receipts. We had a couple large receipts of payments for materials to Lowe's. I mean, we're talking about $2,000 or $3,000 of stuff that were allegedly associated with this project. And when they're asked, well, where did this stuff go?
That's interesting. They didn't know.
Not really clear answers. So whether that's something nefarious, I don't know. Whether they imputed it as something nefarious that folks hearing the evidence, like I said, it was kind of a building block thing where there's just a lot of little things that didn't add up.
And what I think was really important, what you said before you told me all of that, is you had to show the jurors that this isn't the way you would want your church to act and to be run. And that's kind of that whole what Keenan talks about, code and proving their code is wrong, right? Type of thing. So that just undercuts if and obviously it worked in this case. That just undercuts completely the religious shine, so to speak, on the defendant.
Yeah, and we really tried to develop that in discovery. And at some point with these folks, I think we filed 9 motions to compel in this case. Keeping in mind, this isn't a complicated case. This isn't like, a nursing home case with regs and compliance or a medical malpractice case. It's just a normal old email, text, contract, paper receipts, construction case. And so at one point, everyone's always like, well, you've got to make sure you get all the discovery. At one point, I think we got close to the trial date. And I thought, we're going to get a chance to put this case on, even despite COVID. And it's like, we've got enough of what we need in discovery to prove our case. And the stuff that they didn't give us that we don't have, we'll just turn it against them. Right.
How do you do that? How did you do that?
We just asked them, like, check numbers 1 through, where are the rest of the check numbers? It's at some point where, we were asking questions about the lack of things that they produced documentation wise. One of the things that they didn't keep track of was what volunteers were on the construction site each day from the church. During focus groups, we had people say, I volunteer and I've been out to Habitat for Humanity and our church has done stuff like this. There's a sign-in sheet.
Right.
Did you guys get a sign-in sheet in discovery? We're like, no. And those people were like, those people are hiding something. Well, we don't need the sign-in sheet now. All we got to do is say, we asked you for a sign-in sheet. Did you give us a sign-in sheet? And
I love that. I think that's a great idea. That's
an example. There was others, but in trial, when we did this, the guy blurted out, well, I should know who was there because we had everyone from the church sign liability waivers. There had never been a mention from any defendant or the church of any liability waivers ever signed. And so then I said, did you give those to your lawyer? We asked for those. Objection, sidebar, blah, 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 blah. And so I think it kind of came through at some point that.
It sounds like it.
Yeah.
Yeah. One of the things that I think I was always guilty of is we were always so worried about how to prove liability or fault on the defendant that we left damages as an afterthought. And the problem with leaving damages as an afterthought is then you're not proving your case to the jury. Tell me about some of the damages that you had to prove in this case and how you went about doing that.
And I think what you brought up is something we all think about when we put our case together. And the thing I always tell people if they ask me, I say, your case is about what you spend your time on in front of the jury.
Yes.
And you can't ignore liability. You can't ignore damages. If you ignore damages, you're not going to get damages. So the things that we had was, eventually our client had shoulder surgery. He had a torn labrum in the fall. And we had to show essentially that he couldn't do the job that he'd worked for several years before that. He was a union electrician. So you have to do 4,600 hours as an apprentice. You've got to go through the union. You've got to do education. You've got to do 14-hour days doing your apprenticeship and then going to classes at nighttime. And so we had a lost wage and a large lost benefit claim. That was the bulk of our damages was his loss of benefits in this case. And so, we talked about that. We talked about the shoulder injury. We showed, we always want to use demonstratives.
Did he actually have the surgery?
Yes. Yeah. He had a labrum repair surgery. So, I do a lot of, okay, you've got a back surgery, you've got a shoulder surgery type cases. The one thing that I always do in opening is let's do a little anatomy 101. Let's show a video of the surgery that was performed. It's not the actual surgery with the blood and the guts and the gore.
Right.
But if there's a defense expert, there's almost always a video of what is this injury? or
Sure.
what is this procedure? And you can usually use that.
You don't even have to, I mean, you can get that right off of YouTube quite often, as long as somebody, if there's a defense expert.
Off YouTube, and we do that too. But if there is a defense expert and there's something on their website, what are they going to say? This isn't anatomically correct. And so I'm always excited when I get a medical defense expert. I'm like, great, let's go to the website. Let's see what we got to work with.
Sure.
And okay, doctor, you've got this video here. Does this correctly explain a spinal fusion? Doctor, you've got this diagram here. It's a labral tear. Is this what it looks like inside the shoulder? Is this what you do? Yeah. Are these instruments you put in the shoulder? Yeah. Is this where they go? Yeah. Okay. So we always, when we're talking about the injury, we never just say, hey, this guy's got a shoulder tear. He's got a shoulder surgery. We always show a diagram of the anatomy. We always get on some type of anatomical program. And when you're getting deep into the shoulder, we're talking about a labrum tear that's part of the deep joint.
Right.
Highlight the labrum. What's the labrum? What's it do? What's the procedure? Show at least some pictures in a video is better if you're allowed. And that starts from opening. You want them to be aware of, okay, what's the injury? What's it look like? What's the effect? And if they see the anatomy, usually like a labrum is the shock absorber on the shoulder. It gives you motion. It gives you the ability to move without pain. And if they see that, okay, this is what was hurt. They know that from the beginning. You're not waiting 4 days into the case to get to a doctor to explain that to them.
So you've got to really, I mean, if I'm hearing you, and I think what you're saying is, I'm going to embarrass you. I think it's brilliant. I think you're absolutely dead on accurate. You can't just stand up and say, oh, his life was ruined because of a torn shoulder. You first have to let them know what that actually means before you can get them to buy into, and by the way, his life may have been ruined by it.
I think, and I've seen some really good lawyers do this, and I think that we all have the tendency to do it, to assume we do so much medicine and so many depositions about procedures and anatomy and tears and rips and surgeries. We just kind of forget that a lot of people don't know that.
Yeah.
And you've got to show them. You always have to show them the injury. Even if it's something like a connective tissue injury or a non-surgical case, you have to show them the injury. If a nerve is injured, show them the nerve. Oh, I have a low back injury. Well, I have pain up and down my leg. We all know, okay, this is how this works. There's a lumbar injury, numbness and tingling up and down the leg, radicular symptoms.
Right.
I've seen lawyers do whole cases and talk about radicular symptoms and not explain what radiculopathy means. And so it's just, you have to break it down to bare bones, anatomy 101. And I just tell the jurors, I'm like, I'll tell them, like, I didn't know this stuff before this case started. Here's what it means. Here's what you're gonna hear from the doctors. Here's what these term means.
So how do you deal with, especially in a shoulder and a labrum tear issue, of somebody who does physical labor? I don't know your case, but I can guarantee you they're going to talk about arthritis. They're going to talk about pre-existing conditions. They may throw in the whole comorbidity language and start obfuscating and dancing around what's really from this and what he had beforehand. How did you deal with that?
Whenever you've got a case with what they want to call a degenerative condition or arthritis, which we had pre-existing arthritis in this case, grade 4 arthritis in this case, or rotator cuff tears.
Right.
Anything like that, if you let them just stand there and talk about it for 45 minutes like they did in this case, and you don't put it into context for the jurors in relation to what the actual injury is, suddenly it kind of starts to gain credence or credibility. In this case, there was an MRI that showed grade 4 chondromalacia, the initial MRI taken 2 days after injury. So we knew that arthritis was going to be an issue. After his surgery, he had a rotator cuff tear that wasn't in the first MRI. So they're saying, look, there's a new rotator cuff tear here. That's why this gentleman can't move his arm above shoulder level to do his work. How do we know it's the labral tear? And there's no way to stand up and open it, I didn't think, and say, well, there's arthritis here, and here's why it doesn't matter. And
right.
Here's a rotator cuff tear, here's why it doesn't matter. And so what I try to do is we worked, and it took us a while to come up with this, but we said, let's put this in context for the jurors in opening. And when I went through the defenses, I said, look, one of the things you're going to hear, they're going to say, oh. His problems aren't because of his injury in this case or his labral tear. There are these other things. And I go, and exactly what they're going to try to do in front of you, I believe, is they're going to try to turn a molehill into a mountain. And I'm like, in the minute that they do that with the doctor, I am going to stand up and I'm going to show you, if they do that, why they're misleading you. And I'm going to save it for then. I'm curious if they're going to try to go that far. We'll talk about it then. And I showed a slide. I said, here's a mountain, here's a molehill.
So you challenge them in opening. You challenge both the jury and the defense. Are you really going to do it? And jury, I'm going to explain to you, if they do, why they're not being truthful with you.
We knew they were going to go there. I mean, they
Right.
had done, during pre-trial and everything else and motions, it was very obvious that this was going to be a heavy pour
Right.
on why we lose the case. And so we did. I think we came up with a good way to deal with it. We kind of threw down the gauntlet, be like, are you going to try to mislead them? Go ahead and try it. Well, when our treating surgeon testified, and he wasn't.
But let me stop you just for a minute, because I want to make sure I get it, right? So you've got a labral tear that was operated on that your doctor is saying is causally related to this incident, correct?
Correct.
He's got pre-existing chondromalacia and arthritis. And after the surgery, there is a rotator cuff tear that now appears.
Correct.
Am I right on that?
Yes.
All right. So now we're dealing with that issue. Go.
Okay. So they do their cross-examination on these issues. Now we know from really looking at the MRI, this rotator cuff tear is like a 0.3 millimeter tear. It's a very, very small, innocuous, likely asymptomatic tear. The grade 4 arthritis was only seen on one MRI. It wasn't seen on a second MRI. It was never noted by the surgeon during surgery when he's in there in the visual field. And so they do their cross-examination of the treating doctor. He's kind of down the road. He's not pro-plaintiff, not pro-defense, just I'm an orthopedic surgeon. Can I make my testimony as boring as possible?
Sorry.
So after they go on and on about these two things, and can you have these conditions in your arm without any trauma? I get up and the first thing I say to the doctor, I'm like, do you know what a molehill is? And we put up the slide from opening, and the jurors looked at me immediately like, what's going on?
Right.
And the defense, I don't know what he's getting at. I'm like, I'm getting there, Judge. It'll take me I'll be done in 5 minutes. I'm like, my redirect's gonna take 5 minutes. So you're looking at the jurors, you're like, pay attention, this won't take long.
Right.
And the doctor looks at me like, why are you asking me about molehills? I'm like, do you know what it is? We live here in the prairie. It's the middle of Illinois. He's like, yeah, I know what a molehill is. And so we got out a ruler and we put it on an overhead. Okay. How big is this rotator cuff tear? 3 millimeters. All right. I'm marking this down here. 3 millimeters. This is just scale. This is right to you, doctor. Yes. How big was this arthritis? 1 centimeter, 1 square centimeter. Okay. Let's put that down here. Let's color this in. Doctor, did you see the arthritis? No. Okay. So this is this big only if it exists in the physical world. How big is the diameter of the labrum? 16 centimeters. How big was his tear? He tore 75% of it. How many centimeters is that? 13. All right. 13 centimeter line next to this tiny, tiny 3 millimeter line. Did you have to do anything to his tendon, doctor? Well, yeah, he kept pulling. He had this other thing going on. So I had to remove 6 centimeters of his tendon that attached to his labrum. Let's put that on there. Okay. So we've got these 2 huge red lines now next to these 2 tiny little things you can barely see. Doctor, you know what a molehill is? You know what a mountain is? What caused this man's pain and what causes symptoms? What are the mountains in this injury? Oh, yeah, it's the labral tear and the removal of the tendon. These are molehills, right? Yeah. These don't have anything to do with his condition, do they? He's like, no, they do not. That's all.
Did they go back and recross, or they didn't have the guts?
They recrossed a little bit, but they didn't touch on that. It was
okay.
More kind of, I'm going to throw some stuff in the air so they don't end seeing this diagram.
Right.
By the time we got to closing, they did not say the word arthritis, and they did not talk about rotator cuff tears in their closing.
So they just gave up that defense completely.
They did. They had a defense medical expert that was supposed to testify the next day, and he did not appear at trial.
Wow.
So they abandoned their expert.
Now, do you think the fact that A, you threw the gauntlet down at opening, and B, they didn't care. They said, okay, we'll take the challenge. And then C, you did what you told the jury you would do, and they abandoned it. Do you think that affected the defense attorney's credibility and whether they were being truthful to the jury?
I think so. And like, that's the thing. The key to doing something like that, you've got to throw it down and open. You can't wait and start talking about mountains and molehills during the redirect of a physician if you haven't explained to the jury, like, here's what's coming. Here's your cue. We're going to talk about this. I'm going to show it to you. But I think it affects, and I think that's one of the reasons they got off of it so quick, was I think they realized that hit home with some of those jurors.
Wow.
When they saw how big the rotator cuff tear was versus how big that labral tear was, and the fact that it needed surgery, the rotator cuff tear is non-symptomatic likely. When they saw it and they saw that impact, I think they were kind of like, we've got to go with some of these other arguments. And then they resorted to, well, he can do this. He can be an auto mechanic. He can do this job. He can do that job. It's just kind of like an all over the place defense of, well, can he do other jobs? Well, he's working.
Right.
He's doing jobs, but he can't get these union benefits anymore.
So that's great. So now you're in your closing. You've got these issues that we've talked about. How do you put it all together in the closing?
We had to take, there's a lot of documents in this case. There's a lot of receipts and invoices and W-2s and tax returns, and just kind of these things. So you really just want to make it down and make it simple. And something, it's always context. When we talked about the wages and the benefits, you just told them in an opening and bring it back in closing. All we want you to do, all you've got to do as jurors, it's simple. Compare apples to apples. Here's an apple, and I drew an apple. I said, here's his wage. Here's his hourly wage when he got hurt. And here's what he makes driving an armored truck. Okay? This is apples to apples. This is the testimony from the union steward. They're going to tell you, things like, well, this was what his wage was. And this is what his W-2 says. They tried to use apprentice wages instead of journeyman wages. They tried to say, well, he makes more money now working than he did before. Well, he worked 1,000 more hours as an armored truck driver.
Right.
He had a son that they had medical care out of state for I think 6 months of his final year of work. And I knew, it's like, that they're going to go into arthritis. That they're going to go into, rotator cuff tears. They're going to go to take the W-2s and say, look, he made more money his first full year of work after surgery than he did before.
Right.
And you throw that down too, you're like, they're going to try to mislead you. Right from the witness stand, you heard he worked 1,000 less hours when they're trying to say this is apples to apples, not apples to apples. And so you just keep going with every tiny thing that they try to take out of context, use to mislead them. And you just tell them they're trying to mislead you. And in closing, you've got to, I think, when it comes to stuff like that, in Illinois, we have a much ballyhooed issue here. Our minimum wage is going up. A lot of conservative people are like, $15 minimum wage is going to be here in 2 years. That's crazy, And so our client was making $13 an hour at the time of trial. And I just told him, I said, we all know this is coming. We're not going to ask you for a differential between $13 an hour for the rest of his life. Just take what we know, he's going to work. The guy's a hard worker.
Right.
Take the minimum wage. Like, let's not live outside this courtroom. This is what's practiced. This is what's practicable. Use $15. We know it's coming. Like, we're not going to try to mislead you. And I think things like that, you may chop a few dollars off your wage differential, but I think it gets you a lot more in terms of credibility, whether they trust your evaluation of the case, whether they trust your numbers when you embrace things like that. So now juror that knows about.
Absolutely. And you've gotten out to the point, and this always fascinates me, and I ask everybody this. In fact, I talk to people every day and ask them this. So now you've got to explain to the jury in some way or another that this is their time. This is the juror's time to shine. This is their time to stand up for people and make a difference. How do you go about doing that in your closing argument?
I always tell them what the verdict is their personal moral and ethical stamp on what happened in the case, what happened in this courtroom, and how the parties conduct themselves. And in this case, and sometimes I'll do something like this, I'll say, look, they're going to suggest a number to you. And if you give that number, that's your stamp on the case. That's not justice. That's not right. And in this case, I told them, I was like, listen, their whole defense was, well, this was safe enough. Only one person got hurt. It was there for 2 or 3 weeks. No one complained about it. So it was safe enough. It's not safe enough and I talked about some of the professions that some of the jurors had done in the past in work sites and some of that their children did in work sites. Is it safe enough for plumbers? Is it safe enough for construction engineers? Is it safe enough for these people? And say, look, you know that they're doing this good deed, or they're saying they're doing this good deed, but you have to safeguard the safety of all workers in Peoria. Every man and woman on the construction site, when you drive down the road and you see those people working, building schools and building hospitals and making our community better, they have to be protected. They have to be protected, whether it's a big company, whether it's a little company, or whether it's a situation like this. Everyone deserves a safe place to work, which kind of went back to one of the very first things we asked in the jury selection.
Right. So then they come back with a verdict. What's the verdict?
The verdict was $640,000. The offer was $15,000.
Makes it easy. Well, now, did you suggest a number to the jury?
I did. I tend to kind of give a range, especially of the defendant in this case, in maybe where we hadn't sufficiently extinguished some, I'll call sympathies towards this defendant being a nonprofit.
Sure.
And so we gave them a number. I think the number was essentially double what they awarded. So we had, just said, here's where he would have been had he kept being a union electrician. Here's where he's going to be at, making $15 an hour, roughly $15 an hour, the rest of his work life. And here's where his lost benefits from the union would be. You add on pain and suffering, that kind of stuff. We didn't, this is a guy who's working 60, 70 hours a week.
Sure.
This is a guy who's using his shoulder to do most things. They can't do some things above the shoulder at shoulder level.
Interesting. Given that he's still working, didn't that cause you a lot of concern for how much you could really ask for without people getting mad at you?
Yeah, and it's always a concern, in any case,
right?
Conservatory, even more so. It's hard, I think, in Peoria and other places too, to sit there and be like, but we value this case at $4.72 million. I think I know more than you. Jurors, this is what you should give. Other people are amazing at that. I've seen other lawyers do it. They can do it. I can't do it.
Yeah, so have I. Yeah.
And I've seen it done, and I'm like, holy cow, I'm just blown away. I'm like, I could never do that. So I kind of talked to them like, what's this worth? Like some of these things we can put numbers on. They're real easy. Okay?
Right.
Some of these things are not. What's pain and suffering worth? What's disability worth? And so I usually give a range. The first thing I tell them when I start talking about damages or start talking about numbers is, look, I'm a lawyer. These are suggestions. You're the conscience of the community. You decide the value of this type of case in Peoria County, Illinois, or wherever you may be. This is your town. This is your community. This is your county. I'm just a lawyer here. But I will tell you this. I don't know if you're going to agree with my number, but if you come back with some below water number or some defense number, they win.
Oh, so you said that?
Yeah.
Wow, that's pretty good.
I told them, like, if you come back with $200,000 or $300,000, they've won the case.
Right.
This thing isn't even made up for what he's lost on his wages, let alone his benefits and what he's gone through physically.
Nice. Do you think there was one thing that really stood out, or two things to the jury as to why they agreed with you and came back with the 640?
I don't, there was so many defenses in this case based on the church, didn't build the stairs. There was another contractor. I think our clients were phenomenal people. They made a great impression. They were likable. They were honest. And that's the whole thing, was our credibility. Yeah. We didn't put our client up there and he didn't say, I'm in so much pain every day, I can barely get through the day. Our client testified, look, I work hard. I know I'll make money, but I'll never have the ability to make that again. I lost the profession I loved. And that was his damage. It wasn't, I'm disabled, or I can't.
Yeah, I agree. I find jurors really don't react well to the plaintiff or someone complaining and or whining on the plaintiff's behalf. That's a great job, Jeff. Congratulations. Your client must love you.
They're great people. You get in these cases and you say, okay, so did you guys, lawyers are sitting around, they're like, did you win the case? Like, okay, yeah, we won the case. We beat the offer by obviously a fair amount, but those people, what they've gone through and what they went through in the trial, and your clients are always attacked. They deserve every penny of what.
Oh, absolutely.
Yeah. So yeah, of course they're happy. And it's the weird thing is when you go to a trial like this one, or it was just total denial and it's not a degree of the amount of money. I've never had a client, even if you lose, upset. It's somewhat vindication that the jury looked at them and said, this is a valuable case. This is a real case. These people are wrong. And I think that meant as much to them as the money did.
And I think the best thing that you say, and what everybody on this podcast says, is that one of the things trial lawyers do is stand up and give people a voice. And you're only doing that if you try the case. That's when their voice is really heard. Jeff Green, great lawyer out of Peoria. Thank you for joining us today. It's really been enjoyable. If some of the listeners want to contact you, should they just go find you on Google on your webpage, or is there a particular number they can call you at?
Absolutely. They can email me or call me. My email is the letter J Green at jeffgreenlaw.com. And our office, we're located in Peoria, Illinois. And for those folks outside of the Midwest, if you put a dot between Chicago and St. Louis on a map, that would be where Peoria is.
And for everybody listening, Jeff's contact information will be in the notes. So thank you, Jeff. We really appreciate it. It's good talking to you.
You too. Thank you, Saul.
I want to thank Jeff Green from Peoria, Illinois, for just an incredible conversation, which contains so many tips that it was unbelievable, from framing your issues to developing what issues you must address in opening, and some really ingenious ways about how to do that, including something as simple as drawing while talking to the witnesses and to the jury as a result, as opposed to just putting boards up. That extra attention by drawing something, even if it's a stick figure to make your point, can really be the difference, as Jeff told us. Again, thank you, Jeff Green. This is The Jury Thinks What, a podcast for trial lawyers on the Lawyer Minds ecosystem. As always, I am your host, Saul Gruber from Gruber Trial Consulting. And if you listen to this podcast and you thought of a friend of yours who has a trial coming up, let them know. Forward the podcast to them so they can become a subscriber and get these tips. It's all free. And as always, if anybody needs any help, I am Saul Gruber from Gruber Trial Consulting. Just call us. We're here. Thanks, and see you next month. Bye.
That concludes another episode of the Jury Thinks What podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.